Mike, Dave, welcome back to the show. And this is bombshell after bombshell. And, Dave, when I actually got into the papers and started reading them, I thought of you because you're an honest broker. And what you said when the news broke last time you were on about their alleged affair was, we found out that they were denying they had started the affair at the time she hired him. And you pointed out that's legally significant. It does matter if the affair just developed later. It's definitely more beneficial to them if she didn't hire her current lover. And now we see tomorrow we're going to have his former divorce lawyer, who started off as his friend, take the stand, according to Ashley Merchant. His name is Terrence Bradley. And he is going to testify directly, not with privileged information, but based on their friendship, that these two were having an affair long before November 2021 when Fani Willis hired him. And to that, you say what?
Well, first, it's good to be with you on Valentine's Day and Ash Wednesday, Megyn and Mike. I think it's a real problem twofold. First, it does matter when the relationship began. If it began before Nathan Wade was hired, that's a problem. And then it's also a problem if they lied. And if they lied, both of them have submitted information under oath, then there's no question. I would agree with you. They would be pulled off the case. I think that as an initial matter, that Nathan Wade should step aside. Fani Willis should have someone else lead the charge. They already have two other special prosecutors. So just for the appearance, they should have Nathan Wade step aside. But if it is proven that both of them lied and that the relationship, in fact, started before Nathan Wade was hired, then they're going to be disqualified from the case. And when you disqualify a prosecutor from the case, you would disqualify the entire office. This was the issue with the Jussie Smollett, remember, Megyn, where the prosecutor disqualified herself, but her office kept running the case. That doesn't work. That's not appropriate. And then it would get assigned to a different district attorney. But this case would not go away.
Well, yeah, I agree. That's a bigger stretch, although I've heard smart legal experts say it could. It's not the smart bet, but it could. But this is I just want to note for the audience, this is significant because you've been defending her to the best of your abilities thus far. And even you concede that if Ashley Merchant, the defendant, the lawyer for defendant Roman, can prove this, as she's proffered to the court she can, you think Fani Willis and Nathan Wade have to go.
Yeah, and Bradley is the key witness here. And you correctly identify the issue because he was Nathan Wade's divorce lawyer at some point. There are some issues of attorney-client privilege, but he can testify as a lay witness to what he has seen outside of those confines, and he's the key witness. And if they can prove not only that there was a relationship in advance of his hiring, that, by the way, that would be enough. But if they also prove that they lied about it, then there could be more consequences than just disqualification. They could face bar disciplinary actions as well.
That's the thing. So there's so much to go over, Mike. Let me just get your overall take on my opening talking points there.
I think it was spot on. Fani's toast. I actually think that not only will Fani get disqualified and Nathan Wade get disqualified by this Fulton County judge, I actually think the case has to be dismissed, and then a new prosecutor can decide whether he or she wants to refile this case, because this case has been unethically tainted, illegally tainted since before its inception, right? If these allegations are true, it's actually true. I mean, she's admitted that their relationship started before she brought this indictment, right? So she may have hired him. She could be lying about when it started. She could have had this relationship going back to 2020. And if that's the case, both Fani and Nathan Wade are going to face perjury allegations and maybe even prison time. They should go to prison if they lied because they made misrepresentations to the court in response to Mike Roman's motion to dismiss. You had both Nathan Wade file an affidavit, a sworn affidavit, and then Fani Willis relied on that affidavit in her court filing in opposition to Mike Roman's motion to dismiss. So if they lied about that, they should be disqualified. They should be disbarred. They should be charged with perjury. They should be put in prison.
And let me just jump in. I don't want. I'm sorry to interrupt your train of thought because I really do want to hear your overall thoughts. But just for the record, Nathan Wade submitted a sworn affidavit. He's under oath and he's subject to penalties of perjury. She signed the brief representing to the court both what he said in his affidavit and, one presumes, as an officer of the court, that, I'll read it, Attorney Willis and Special Prosecutor Wade have been professional associates and friends since 2019, but there was no personal relationship between them in November 2021 at the time of Special Prosecutor Wade's appointment. So she puts that herself in a brief that she signed. That's not a perjury thing, but it's absolutely an ethical thing. You cannot knowingly mislead the court as an officer of it. So keep going, Mike.
Well, I mean, if she's aiding and abetting perjury, that's perjury. But I would say this, remember, and technically she didn't sign, she had one of her subordinates sign that brief, but her name's on the brief as the Fulton County attorney. Yeah, so she would absolutely be liable for that filing, right? So look, if these allegations are true, I think this case has to be dismissed. And then you bring in a new prosecutor, whether it's the state attorney general, Chris Carr, maybe it gets assigned to another prosecutor elsewhere in the state, and then they're going to have to make the independent judgment free from this financial conflict of interest that Fani Willis is making money off of this prosecution of President Trump and 18 co-defendants based upon a bogus, novel RICO conspiracy theory against political opponents. A new prosecutor is going to have to come in and have independent judgment whether they're going to bring recharge President Trump and these 18 co-defendants. But I absolutely think this case needs to be kicked.
Okay, so here's what she's saying, Dave. I mean, this is huge. These are very, very big stakes we're talking about right here because, you know, he really needs to pull an inside straight to avoid all these charges, and he's on his way to doing it, is really how this is looking, given there are delays in the Jack Smith federal trial in D.C., the New York case people don't care about as much, the Miami case based on the Mar-a-Lago documents, that's Dave's jurisdiction, is slow-rolled entirely because of all the classified documents thing, and it's a friendly to Trump judge there, so he's got that going for him. And so this case is potentially very problematic for Trump, and this is an amazing development for him. So Terrence Bradley is the former Nathan Wade divorce lawyer who Ashley Merchant, the lawyer, says she's going to call tomorrow. And not just him. She's got a whole list of people she's ready to call in case, I don't know, he gets impeached. I don't know, just to back him up. We'll see. But here is what the defendant, Michael Roman, argued in his brief about Terrence Bradley. They say Willis and Wade claim they didn't have a personal romantic relationship before Willis appointed Wade as a special prosecutor, but Terrence Bradley will refute that claim. Bradley is an attorney and member of the Georgia Bar. Bradley and Wade were friends and business associates. Bradley has non-privileged personal knowledge that the romantic relationship began prior to Willis being sworn in as district attorney in January 2021, so well before. Thus, Bradley can confirm that Willis contracted with Wade after Wade and Willis had begun a romantic relationship, thus rebutting Wade's claim that they didn't start dating until 2022. It goes on. Bradley obtained information about the relationship between them directly from Wade when Wade was not seeking legal advice from Bradley. He obtained this information in a personal capacity as Wade's friend prior to Wade's decision to file for divorce. While Bradley would later represent Wade for a time in the divorce proceeding, the information about the relationship was obtained prior to the attorney-client relationship beginning. None of Bradley's testimony will relate to any privileged info or work product. Bradley also has personal knowledge that Wade and Willis regularly stayed together at her home until Willis's father moved into her home sometime in 2020. And they go on to allege they'll be able to prove cohabitation of some sort. So that's what we're going to hear from Terrence Bradley. And then here, just flipping now, Dave, to Nathan Wade's sworn affidavit. He says, while professional associates and friends since 2019, there was no personal relationship between District Attorney Willis and me prior to or at the time of my appointment as special prosecutor. Because I was thinking, Dave, maybe he could get out of it by saying he just alleged in the affidavit at the time of, it was off again, on again. Maybe that's how he wiggled out, but no, he says never, not prior to, not at the time she appointed me. And it wasn't until 2022 that we developed a personal relationship in addition to the professional friendship. And on it goes. Oh, and he also says, I have never cohabitated with District Attorney Willis, which Ashley Merchant is also going to take on through witness testimony tomorrow. I mean, if she can prove these are lies, and look, the affair, when it began, like the judge is going to be able to make a judgment call, Dave, on who's telling the truth there.
Yeah, and Judge McAfee's doing a great job here.
I do think he's doing well. I agree with you. Just watching him at this hearing, he seemed like a straight shooter to me. I haven't seen much more, but what I saw in that hearing was a fair, normal judge.
What's amazing about him is that I think he's only 35 years old, which I think belies his gravitas. And maybe it's because he has that receding hairline. But whatever it is, he's doing a good job. As far as this development here, I think a lot depends on what the personal relationship is. That's kind of a broad term. Is it enough if they show that they had a sexual encounter before he was hired? Is that enough? And I think it's a sordid question, but Judge McAfee's going to have to delve into that. What kind of personal relationship did they have? So the devil really is in the details. And as far as cohabitation, actually, I think that's their weakest argument, because according to what I've seen, that Fani Willis is going to have a sworn testimony that there was no cohabitation. So I think it's going to turn on what was their personal relationship. Did it really, are they trying to mislead the court? Did they have a one-time fling, or did they actually have some sort of relationship that would disqualify them?
Okay, but we've buried the lead in our discussion, though not in my opening, which is, Mike, why would an officer of the court go back and amend sworn interrogatories, which are written answers that are provided under oath in any proceeding? You know, you have to write down all your things and swear to them before the lawyers get to depose you, in which you say the things under oath. He went back, according to Merchant, had to amend his denial of having an affair on his wife and pleaded the fifth in his amendment in that divorce proceeding.
That doesn't make any sense whatsoever. When you go back and amend interrogatories, it's for like technical or clerical errors. It's not for substantive testimony that you're completely changing your substantive testimony. You can't just go back and amend a lie and then claim the Fifth Amendment, and that you think that protects you from false statements to the court or perjury to the court. That's not how it works. But
isn't it admission, Mike, that he did he admit there basically that the earlier answer was a lie? I mean, honestly, like, I'm trying to dumb it down for myself and everybody else. What reason would you have to amend your sworn interrogatory answer by pleading the fifth, other than you think telling the truth is going to get you charged criminally? So I'm trying to follow. Does he think he's going to be charged criminally for lying in the original interrogatory answer? Or does he think he's going to be charged criminally for something he's done in the Fani Willis case?
And I don't know why his lawyer would, or maybe he just did this on his own. You can't just come in and testify and then assert the fifth, right? You can't play that game with the Fifth Amendment. With the Fifth Amendment, you either testify or you don't testify. You can't selectively testify and then change your mind and then assert the fifth. That's not how the Fifth Amendment works.
What do you make of that, Dave? Going back, originally saying in the divorce proceeding, I never had an affair. Then this motion gets brought in this other unrelated case, and he gets caught. He knows he's going to have to admit that they did have an affair during the marital years. And he goes back. I can kind of see amending and saying, there was one. But I don't get amending with the Fifth Amendment.
I guess if you file a sworn document that says that you did not have an affair, but then it's true you had an affair, then he's worried perhaps about a perjury charge, and so that's why he could go back. I'm viewing this in the divorce proceeding.
In the divorce proceeding, a potential perjury charge. Okay.
Yeah, right. So it is possible that this doesn't relate to Fani Willis. I'm looking at this in the most positive light towards Fani Willis. That doesn't have anything to do with this current case. Yeah, but I admit, look, this looks bad, but we don't know if he went back and amended it to protect himself from the current case involving Fani Willis. It may be just to protect himself against perjury the first time around.
Either way, he is in what we call in the law a shit ton of trouble.
Which is why he should step aside. He should step
Yes,
aside.
this is terrible. Mike, I'm sorry, but like, am I overreacting? I've never seen such an ethical breach. Okay, you had an affair. This is bad. The whole thing stinks. Yes, you've jeopardized one of the biggest cases in the nation against Trump and the probably, almost undoubtedly, the biggest case in Fulton County history ever. But then you lie under oath to the court about it? Like, other lies are uncovered. And we haven't even touched on, Mike, the alleged lies about the expenses. He says we shared them roughly equally. And then I said, great, okay, this is kind of what Dave had raised this, saying maybe, we don't know. We know that he paid these numbers, but maybe she reimbursed him or maybe she paid for some. So, okay, we were all open-minded to that. So I'm like, great, that's what he's saying. Let me see it. And I look at his exhibit, which he points me to. Okay, hold on. The airline tickets. Okay, great. He says it's Exhibit 4. Here it is, Exhibit 4. I get there. And we got one page, which says Fani Willis. It's a November 30th purchase, 2022. Delta tickets from Atlanta to Miami and back, leaving Friday, December 30th, coming back Tuesday, January 3rd. 2 tickets. One ticket here for Fani Willis and one ticket here for Nathan Wade. And the price is listed at, for each ticket, $697.20. Okay, great. That's one. I'm looking for, they took 10 trips. I'm looking for 4 more, right? Let's see. She did 5, he did 5. I'm open-minded to you, Fani. It's not in there. It's not in there. What happens after that is nothing. Other exhibits. That's the only proof of roughly equal. So this is another area in which his affidavit seems blatantly misleading.
I mean, isn't 10-1 roughly? I mean, is that not how we look at roughly?
Really rough.
I mean, this is very rough. I mean, look, at the end, we all know that Fani Willis is toast here. I mean, she is going to get disqualified. Nathan Wade is going to get disqualified. I don't know how they don't get disbarred if it's proven that they made these misrepresentations to the court, material misrepresentations to the court. I don't know how they don't get charged criminally. So this is going to get a lot worse for old Fani and Nathan Wade before it gets better.
What do you make of that, Dave? Because I have heard, it's not just Mike, who we know is a Trump fan and advocate, say they could be facing disbarment and there actually could be a criminal prosecution and or dismissal of this case. And it's interesting what Mike was saying. He's not necessarily saying it's dismissed and it never comes back. It's dismissed, and if there's another prosecutor who wants to try to bring it, okay, that could potentially happen. Jeopardy hasn't attached. They haven't picked a jury. So can you speak to those 3 terrible outcomes for Fani? Like, good, all good for Trump. But can you speak to those possible 3?
Sure. I don't think the case will be dismissed. If this case were weak, then Judge McAfee could have dismissed it already, but he hasn't. So because of that, this case will continue. It may continue under a different district attorney. Now, the way it gets reassigned, I think it goes to the attorney general in Georgia and then reassigns it. We saw that in the Armand Aubrey case. But I think there's still a shot that Fani Willis stays on the case. I think Nathan Wade needs to be separated from the case. I think he'll be gone from the case. But as far as Fani Willis, until you can prove, I think, that she lied, then I think she stays on the case. Here's the thing. But
if he's gone because he lied in his affidavit, she's gone too because she signed the brief. It's her brief. Right. And as you well know, the lawyer submitting the brief is the one working with the defendant who signs the affidavit. As Mike points out, she's a co-conspirator basically on the lie, and her brief retells the lie. It's her brief. She signed it. Not to mention the underlying ethical breach of the affair and all the monies. Like, we've just moved on to perjury here. So there's no world in which he goes and she stays.
Well, if she lied because she submitted that brief with her name on it, then she would be gone because that's beyond the pale. When you say, and you talked about with Mike, how it looks like they did not reimburse each other, it wasn't halvesies, it wasn't roughly halvesies. I have always thought that if the affair started after he was hired, then it doesn't have to be halvesies or roughly halvesies. But the problem is that they've made a sworn declaration that it is a roughly half and half situation. So because of that, if they lied, then they both have to be gone from the case.
And do you have any thoughts on the possibility of losing your law license, facing criminal penalties. Andy McCarthy's coming up right after you guys. And, he's a serious, sober lawyer who I'm sure you guys both know and respect. He's been talking about how she could face some criminal penalties here.
It's always possible. Perjury is a crime, although I got to tell you this, from a prosecutor's perspective, you don't see a charge very often. Because you've got to prove it's knowing, and you've got to prove definitively that they lied. It's not always easy to do. You're going to have testimony, and you're going to have testimony both ways on this. And then you have to get into the granular issue of what a personal relationship is before Nathan Wade was hired. It almost is what the definition of is. And because of that,
if they were having sex, they're done. Right. I mean, that'll amount to personal by any measure.
I do think that. It depends. It depends. If it was a one-time thing, then I don't think that's enough to get him for perjury.
Stop it. Okay, so we're going to be taking testimony tomorrow on how many times? How long were you in the sack for? Walk us through it. Was it meaningful to you? Were there flowers exchanged? It's Valentine's Day. Mike, I don't believe any of that. But, there's going to be a come to Jesus moment tomorrow. Fani Willis did not want to have to give testimony. Nathan Wade did not want to have to give testimony. They're going to. The judge has said it's happening. And we expect, at least based on how I understand it's going to go, there's going to be a moment where Fani Willis is asked under oath. She hasn't been asked under oath yet. When did the affair begin? And if she says not until 2022, then it looks like this guy Terrence Bradley, is going to try to put the lie to that, among others. And if she changes what she wrote in her brief and what Nathan Wade said in his affidavit and says, actually it was before 2022, she's in trouble for a whole host of other reasons. So it could come down to a credibility contest between Fani and Nathan on one side and Terrence Bradley and I guess whoever else they're going to offer on the other, right? It could devolve into, who does the judge believe, Terrence or these other two?
I mean, here's the problem for Fani. Both Fani and Nathan Wade submitted their court filing on February 2nd, and they included Nathan Wade's February 1st affidavit that they knew was a lie, right? And then they had 8 other attorneys in the Fulton County DA's office put their names on this February 2nd filing. So you have 10 attorneys in the Fulton County DA's office submitting something to the court. At least two of them know what they are submitting is a lie. That is not going to go over well with this judge. That's why I'm saying that this case is so tainted that it should be dismissed and bring in a new prosecutor with fresh eyes and independent judgment who does not have a financial stake in the outcome of this case like Fani Willis and her boyfriend, Nathan Wade, apparently do.
This is just incredibly stupid, reckless behavior. I mean, I don't know, Dave. I know you're doing your best to defend her, and I appreciate that because we like to get both sides here. But honestly, tell us the truth. If you had a lawyer prosecuting a case this big, working for you, and you found out that she'd been having an affair with a special prosecutor that you had to bring in, getting paid on the taxpayer dime, going all over the world with this guy, not disclosing it to anybody, and then you found out that the affair had been taking place prior to the date she brought him on, and then that she submitted an affidavit from the guy that she signed the brief for saying that wasn't true, and there was somebody about to take the stand, another officer of the court, a lawyer, who's going to say, those are lies. I can tell you firsthand that what? I mean, you'd fire this person. This is a massive ethical breach if true.
Yep. And it's different, though, if you're the boss, because who then fires the boss? It's up to the court. It is much easier to fire the boss than it is to file perjury charges. I guess that's my point here, is that the granular investigation that they're going to have to do in court is going to make it very hard, I think, to charge her with a crime if they found out that Nathan Wade's affidavit was a lie. But I do think that they would both get bounced from the case, and Nathan Wade should not be part of the case anyways. He should be separated from it. And Megyn, to your larger point, it has been difficult from the beginning to defend this, because if you're going to go after the former president, you have to be squeaky clean because all eyes are on you. The spotlight is on you. This has never been done before in the history of our country for a local prosecutor, other than Alvin Bragg, to go ahead and file charges against a former president, especially with an election looming. So you have to make sure all your T's are crossed and your I's are dotted. And apparently they didn't do so here. And this just opens up so many conspiracy theories. And although it doesn't jeopardize the ultimate case, in my view, it does look bad.
It could jeopardize the ultimate case, though, because you mentioned how the AG would have to assign a DA to replace her. The AG in Georgia is a Republican. Now, I don't, and there are questions about which, if any, DAs would be willing to pursue this wacky RICO case that Fani's brought. So it's not a foregone conclusion that if she got bounced, it'd be super easy to just pass the baton to somebody else. Mike and Dave, great discussion as always. Thank you guys so much for coming on.